Hello everyone. I hope this message finds you fit and fine. My name is Shashank and I welcome you all to our contest series on Indian polity. In our previous class, we were discussing fundamental rights. Specifically, we started with the conception of right, type of rights, natural rights, civil rights, legal right, political rights. And we also discussed Article 12 and Article 13. Today we need to discuss right to equality, Article 14 to Article 18. You will be surprised to know that in many parts of the world, constitutions were not having equality as an important pillar. But can you think of our constitution, this administration, without concept of equality in place? And why you think like this? Why equality is so much important for us? I hope the direct answer, one answer would be, if there is no equality, then it would be like system is based on injustice, right? But in ancient and medieval time, equality as an idea was not that much prevalent. Even people were not demanding equality from their government. It was in modern time that people started demanding, yes, we should be treated equal. There should not be any basis of discrimination. Social realities should not be the basis of discrimination in eyes of law. So this is a modern concept. It is connected to liberal values. And why I am discussing all of this? Because nowadays UPSC is asking question on these lines. The conception of right to equality as a fundamental right is connected to liberal value. So this line you are not going to find in Article 14, 15, 16, 17, 18. This is based on your understanding of this very concept. Now these are the articles, and I would like you to give attention to these words. For example, in Article 14, the word person is used. The state shall not deny to any person equality before law, equal protection of law. We are going to discuss this in detail, but the point is person. In Article 15, although we see the word citizen, its state shall not discriminate against any citizen on grounds only religion, race, caste, sex, place of birth, or any of them. Any of them means of these. Now in Article 16, again you see the word citizen. There shall be equality of opportunity for all citizens in matters relating to employment or appointment to any office under the state. Means we are talking about government jobs. Article 17, abolition of untouchability. Article 18, abolition of all titles except military and academics. So this is right to equality as a portion. Now, right to equality has a lot to do with this concept of rule of law. And at this point, we should remember Mr. A.V. Dicey, because he popularized this idea that law should be supreme. When I say no, law should be supreme, it means no one is above law. Now you should think on these lines. Do you think in India, rule of law is present in letter and spirit? Do you see that some politicians flout some rules, specifically COVID rules in some election rallies, and there is no challan against them? But if you were going and you were sitting in a car, you were challaned, right? Say 5,000 rupees. So this example reflects that this concept, no one is above law, seems like it is not applicable here, right? But we have examples like Norway, where even Prime Minister was actually challaned, means action was taken against Prime Minister by the local sheriff because she invited 2 more persons in her birthday party. That was not allowed as COVID guidelines were in place. Now my point is that why so much importance to this? Because if law is supreme, then it will reduce the chances of arbitrariness. If it will reduce the chances of arbitrariness, then you can be sure of that the system will work as per the provisions mentioned in law. It means justice can prevail in that context. Abuse of power will get minimized. And that is why this concept of rule of law is important. Equal treatment. And this concept can be seen in this Article 14. Because Article 14, as we just read, has two specific keywords: equality before law, equal protection of law. I think it is not visible in front of you. It will be visible in subsequent slides. Apart from equality before law, equal protection of law, we also have access to justice, another important component of Article 14. And we have this equality as an idea specifically mentioned in our preamble as well. Now, these are the two key phrases. And this equality before law is taken from British Constitution. My friends, this is considered as a negative conception. When I say negative conception of equality, it means that state shall not do this in order to bring equality before law. It is a generic concept that everyone should be treated equally in eyes of law. Seems like a nice idea. Then why our constitutional framers added this phrase, equal protection of law? This is taken from American Constitution. So they have their rationale in place. Reason. Equality before law, this concept says it means that no man is above law. Don't you think this line is connected to this concept of rule of law? And I've just told you the benefits of rule of law, right? Every person, whatever be his, her status or rank, is equal in the eyes of law, right? This is equality before law. And when we are reading it, you should not relate it with practical realities like some powerful people, get some easier way to actually avoid certain implications of punishment. That is practical part. But the point is, you should uphold these ideals. You should know why these ideals were added in our Constitution. Because whenever you have clear-cut idea that this is how system should work, then only we can actually take steps in that particular direction. So equality before law is clear. Now talking about equal protection of law. I told you it is a positive conception. It's a negative conception. Means everyone should be treated equally, right? And there should not be any discrimination. But this is positive conception. Means you have to do something. Do what thing? For example, equal protection of law says that unequals should not be treated equally, and equals should not be treated unequally. Some of you might be thinking, what is this? Syllogism? Nahi. Take practical example. If you and your friend are equal in so many parameters, and now government is treating you unequally, would you respect that kind of system? Would you like that kind of system? You would say obviously no. But what is happening here? Equals are treated unequally, and that is why equal protection of law says that equals should not be treated unequally. And if there are unequals, consider this example that this board is a wall and there's a match going on other side, right? And I'm teaching here and you are in the class and you want to watch that match. So I allowed in 15 minutes break that yes, you can watch that match. But due to this height constraint, you're not able to see it. So you ask, sir, can we have some benches over here? Some placemats, some stools here? So I said, okay, it can be provided. I'll ask the management and they will do that. So now some of you might be of this height, some people of this height, and some people of this height. And all of you have paid equal fees. Now you are expecting that there will be equal treatment to you, right? And consider this example, you want that equal expenditure should be given to you. Equal expenditure should be done for this, for allowing you to, for arranging that you are able to see that match. But at this point of time, what is required? The person of this height need to be provided with a, you can say, a chair or some arrangement of, you can say, this much height. That may cost me, say, 800. Okay, I'm making a proposal that whatever I'm going to give you to see this match, this will be yours. Take home. Now, a person of this height might require of a chair, or you can say stool of this height, and this one the minimum height. Now, the person who got the stool or chair of maximum height, then other might say, sir, you have spent 1,000 rupees for that student, and you have spent just say 100 rupees for me. This is disparity. Then I would say that students, that unequal criteria is being used here. Unequal in terms of height. Unequals should not be treated equally. Because if I treat you equally and give you equal height, arrangement, then it would be injustice for others, right? So that is why this criteria is cleared by this concept, equal protection of law, right? And state will make efforts to actually allow people to make use of law so that they can protect their interests, and take many actions. For example, establishment of bodies like NALSA, National Legal Service Authority. Similarly, we have SALSA, not the dance authority, SALSA, State Legal Service Authority, by which we provide some government advocates on a very minimum fees or free to actually fight your cases if you are not having that financial capacity. So it means that like should be treated alike. The state cannot treat unequal people as equal. I hope now it is clear to you. Apples and oranges are not the same. Thus, it gives freedom mandate to the state to make a special provision for the disadvantaged section. For example, this NALSA of society. For example, affirmative action laws, special laws for women, children, etc. So this is a specific concept. Now there are some exceptions to equality. Take a look, Article 361. President and governor is not answerable to any court in the exercise and performance of the powers and duties of his office. This is an exception. President and governor will not be treated equally like you. Similarly, criminal proceedings shall not be instituted against the president and the governor during their tenure. If there is any case, then in that case, first they will be impeached or governor will be removed, and then criminal proceedings can start. But till the time they are in this position, criminal proceedings cannot start. This particular clause was in news during Sheila Dikshit, the time when she was governor of Kerala, and there was a case of CNG scam, and one section was demanding that criminal proceedings should start, but they could not start because she was governor of Kerala at the point of time. Now, Article 194, 105, no MP, MLA shall be liable to any proceedings in respect of the actions which they perform in the House. So this is part of parliamentary privilege or state legislature privilege. Now, the foreign sovereign ambassador, now there is exception to them also. Why? Let me give you an example. So, consider you are traveling in a car and take a look over the number plate. Your car number plate is having white background and black alphabets and black digits, right? So it's represent that you are having a private vehicle, right? But say Mr. Rohan. So Mr. Rohan is a diplomat, and by virtue of this position, he may be given a car which is having number plate with blue background and white some alphabets and digits. For example, 12CD07. These kind of numbers are on these cars. These are diplomatic cars. Now, both of you are traveling on the same road and you hit one person and that car also hit another person, right, at the same moment. Then when the police reaches there, you will be stopped. Your car may be seized. You will be told that you have to come to this police station. But when it comes to that car, diplomatic car, that diplomatic car will be given free pass. And it will be communicated that yes, we are going to communicate with the respective embassy in this regard, but that particular person will not be stopped. Why? Because diplomatic immunity is given, right? In that context, you cannot say, oh, I have read right to equality as mentioned in our preamble, or equality as mentioned in our preamble and right to equality as mentioned in fundamental rights, and this is wrong. No, no, no. You should also read about the exceptions, right? Now, prohibition of discrimination on certain grounds. That is Article 15. Have you seen that movie Article 15, Ayushmann Khurrana? So, Article 15, Subclause 1. First of all, you should be clear that it applies only on citizen. Only on citizen. Okay? And not for non-citizen. It should be clear to you. And prohibits the state for discriminate against these citizens on the basis of religion, race, caste, sex, place of birth, right? So the state shall not discriminate on this basis. And the word only is used here. What does it signify? It means discrimination can be done on basis which are not mentioned in Article 15, Subclause 1. Now some of you might think, oh sir, how is it possible? Why they use the word only here? Why the word only here? Because we should be against discrimination. Why we are giving scope that only on these bases discrimination cannot be done by state, and on other bases it can be done? Because whatever is not clearly prohibited in a law, it is deemed that it can be done. So my answer is that discriminate as a word is generally used in negative context, that this is bad. But in legal language, discrimination can be used in positive context also. When I say positive context, it means some special provisions can be done for some weaker section. That would be discrimination. But don't you think that this discrimination can support the idea of equality? Right? So that is why discrimination can have positive context also. Right? Now these cases were in news. For example, Sabrimala Ayappa temple issue, right? There, in this case, when women in menstruating age from 10 to 55, they were prohibited to enter into Ayappa temple. Then Supreme Court, what it says? It is against Article 14, it is against Article 21, it is against Article 17. We are going to learn all of this. But the point is that at that point of time, this decision was taken that it would be discrimination. That is why it is prohibited. Similarly, preference for male in active military service. You must have seen that now permanent commission is given to female as well. Then this admission into gynecology. Recently there was an article where Rajasthan government said that male gynecologist will not be allowed to treat women. Gynecologist, it means that genre of medicine where they study the women body and they deal with providing solution to women problems. But the point here is that should be gender neutral. And later that government took this order back, right? Now, Article 15, Subclause 2. Now, please give attention. This is applicable not just to state, applicable to citizen as well, to private individual as well. It means you cannot do discrimination also, right? A state with even citizens should not discriminate on these 5 grounds. What are the grounds? Religion, race, caste, sex, place of birth, right? For example, public places like restaurant, shop, well. So you cannot say that, oh, this other person belongs to this religion, that is why I'm not going to allow this person to actually have water from well. And why our constitutional framers mentioned this word well even? The reason is they knew the ground realities. How people on the basis of their caste were restricted from having this drinking water from common well, right? And this is a, you can say, social evil. So to eradicate it, this particular provision was added. Apart from this, it is also cleared that wholly or partially or state funded infrastructures, areas, places, you cannot actually have discrimination on this basis. Why this was mentioned specifically? For example, if you are having a garden in front of your home, and this is a privately owned garden, private property, and someone belonging to any religion, caste, place of birth, they want to enter into that garden and enjoy this sunlight, and you are prohibiting that person, you cannot enter. So now it is fine because that is your private property, right? But now consider, this case is applicable in case of park of your society. Can you prohibit the entry of a person based on religion, race, caste, sex, place of birth just because that this person belongs to this category? No, you cannot do that, because it may be possible that this park is being maintained by state funds, wholly or partially, right? If state funds are used, then you cannot discriminate. In case of private property, your own rules of entry and managing can be applicable. Okay. Now, Article 15, Subclause 3, special provisions for women and children. Now, why this was added? Because our constitutional framers and later our legal luminaries were well aware of the fact how people are going to interpret these articles, right? Some of you might say that, oh, it is quite clear when it comes to state-funded institutions, government institutions, there cannot be any discrimination on the basis of, say, sex, right? And now state has made an institution, say a girls' college, and state is saying only girls admissions are taken here, right? And now one bright student, you can be that bright student, and you are actually knocking on the doors of girls' college and barging into the principal's office, and you are saying, ma'am, I want to take admission into this college. Now, principal is saying, beta, this is girls' college. But you are saying, no, ma'am, Article 15, Subclause 2 says that if any institution is state funded, then there cannot be any discrimination based on sex. So how can you discriminate against me on the basis of this gender? I want admission in a girls' college. Then ऐसा भी हो सकता है that you will get a laugher, you will get a slap from the principal, and she will say that you should read Article 15, Subclause 3, right? And if principal is going to ask who has taught you polity, so don't take my name, because I told you that state has this power to actually make special provisions with respect to women and children, right? So this particular women college will come under special provision as per Article 15, Subclause 3. So we can say it is a positive discrimination. For you, it's a discrimination, but it's a positive discrimination. For upliftment or the welfare. Similarly, stopping child labor, reservation for women in parliament. These associated issues are connected to Article 15, Subclause 3. Now, 15, Subclause 4. Now, there's an interesting story behind it. This was not part of original constitution. What happened? So it was Madras state which actually made some reservation, right? And this reservation was around 68%. At that point of time, one girl, Champakam Durai Rajan, she wanted to take admission in medical college, and there were only two government medical college in Madras at that point of time, and there were two engineering college. There was another boy, Srinivasan, who was also fighting to take admission into that engineering college, both belonging to general category. And Champakam Durai Rajan filed a case, and she said, actually it is against this policy of reservation is against my fundamental right. Then court asked how it is against fundamental right. She said, sir, it is against Article 15. Because Subclause 4 was not there. Article 15 was saying that there will be no discrimination on the basis of religion, race, caste, sex, place of birth. Then why court has made a special policy for reservation for a particular section? So at that point of time, the government replied, we have done this under the spirit of Article 46. Article 46, Directive Principles of State Policy, which gives this directive to state. The state has to take certain actions to secure the welfare of this backward classes. So state gave this decision. So Champakam Durai Rajan case actually put forth a debate which should be considered superior, fundamental right or DPSP, because her fundamental right is being abridged, and on the second point, state is saying we are actually securing the welfare of the deprived section, taking inspiration from DPSP. At this point of time, court observed that if we read Article 37 within this DPSP part, Article 37 says that DPSPs are not enforceable in court of law. And if they are not enforceable in court of law, it clearly represents that fundamental rights should be considered superior to DPSP. So this case went into the favor of Champakam Durai Rajan, and this was the first case in the history of independent India which was majorly having this debate on reservation policy in India. So as this case was in favor of Champakam Durai Rajan, as a reply, what government did? Government made first constitutional amendment in 1951. And my friends, this was the time when we were not having, we did not have elections per se at that point of time, right? Full-fledged parliament was not there. Now, they made this constitutional amendment and provision for advancement of backward classes and SC/STs was added. So what was added? Article 15 subclause 4 was added. And as a result, no reservation on communal lines, this was accepted. But reservation can be done for the backward classes in SCs and STs. And why this word no reservation on communal ground? The reason is Madras government declared this reservation policy on the basis of a government order which was released in 1927 in Madras state. 1927, I'm talking about when we were not independent. And this government order was later recognized as communal government order. That is why CGO word was also used. Why? Because reservation was not just given to SCs, STs or backward classes. Reservation was given to Anglo-Indians. Reservation was given to Muslims. So it means religion was also a basis of giving reservation. So that is why in Champakam Durai Rajan case, the advocate was saying that if Article 15 is saying that there will be no discrimination on the basis of religion, and you are specifically giving reservation in education institution based on religion, then this is communal order. This is against Article 15. Right? Now, I hope this debate is quite clear to you. At one point of time, fundamental right, and on other side you have this DPSP backed by Article 46, and then interpretation happened using Article 37. I hope this debate is clear. Now, talking about Article 15, subclause 4. So case, the background, Mysore government reserved 68% seats in medical college. So Mysore, where we right now have Karnataka. So there was another case. It happened after Champakam Durai Rajan. M.R. Balaji versus State of Mysore case. Now what happened there? The debate was that whether this government has this power to demarcate that certain seats will be reserved for a section by an executive order. Because it may be possible that government should actually bring a commission dedicated to give advice to the government that what efforts need to be made for this backward section SCs and STs, and then this matter can be given to president, and then president can actually bring a bill in parliament, and then this can be you can say implemented in the other states. So the debate is whether commission is needed, whether such reservation policy can be enacted just by executive order or law is needed, means law made by legislature. Third, whether it is necessary that only president can actually issue guidelines regarding reservation or state government can also do the same. So on these debates, finally this M.R. Balaji case happened. Now, both socially and educationally backward classes, they were recognized. At that point of time, here, there was also categorization between backward class and more backward class. And question was raised, no such categorization is there in our constitution. So, should we agree on this? And when I say backward, so what kind of backward you are talking about? And that is why it was clearly mentioned socially and educationally backward classes. Caste cannot be dominant factor while considering backward classes. It means socially and educationally both components need to be added. It may be possible in a social structure, a particular caste may be regarded as a lower caste, but the people from this caste actually got a lot of education in past, and that's why now they're from education perspective now they're quite strong. So in that case you cannot give reservation to that particular caste. So such debates were going on. No reservation beyond 50%, for the first time it was accepted, right? It was Indrasani Case who actually finalized the stamp, put the stamp on this. Backward class distinction into backward and more backward is not valid, as I told you. So it was not valid, no reservation beyond 50%. So this was M.R. Balaji versus State of Mysore case. Article 15, subclause 4. It is related to advancement of backward classes. So whenever Article 15, subclause 4 comes into light, so you should remember two cases, Champakam Durai Rajan and M.R. Balaji. Okay. Now, Indrasani case, the famous judgment on reservation policy, it clearly said not more than 50%. Also declared this concept of creamy layer. It means from OBC also, there may be a category of caste or subcaste which are in creamy layer now, based on the criteria issued by the government. Creamy layer means now they will not be having benefits of OBC reservation policy. Classes can be classified and it's constitutionally accepted, means backward and more backward classes can be classified. So in M.R. Balaji case, it was not considered valid, but in Indrasani case, it was accepted, yes, we can have categorization within backward. Now, why Indrasani case changed the stand which was earlier made in M.R. Balaji case? The simple reason is because concept of creamy layer need to be incorporated, right? If from backward classes, some backward classes are more backward, then they should be the one who should get the benefit, right? Backward class can be defined only on the caste. This actually gave a, you can say, idea which was not formalized at that point of time, but this seeds were sown that whether we can think of segregating reservation policy based on subcaste concept. Because within a subcaste, if you categorize that this subcaste is more backward, this is less backward, so application of reservation policy may change, right? And this concept was later taken up by Justice G. Rohini Committee also. That's a star point, you should search about it, Justice G. Rohini Committee. And what are the recommendations of Justice G. Rohini on this concept of OBC reservation? Backward class cannot be defined only based on caste, means education criteria is important. Now comes Article 15, subclause 5, admission of OBCs, SCs, STs. It means, now the debate was, now when it comes to education institution, so whether this reservation policy benefiting OBCs and SCs and STs welfare should be incorporated in private education institutions also. So this debate was cleared after this Article 15, subclause 5. 93rd constitutional amendment was made to add Article 15, subclause 5, so that state has the authority to impose laws that apply to all education institutions, all, means including private institutes, whether state aided or not. And we have exceptions here. For example, madrasa are exception there. Central Education Institutions Reservation and Admission Act 2006, 27 reservation quota for non-creamy layer OBCs was used, because creamy layer won't have this reservation. Now, Article 15, subclause 6, reservation for economically and weaker section. It was brought by Modi government. At this point of time, so many advocates were saying that this particular provision, Article 15, subclause 6, will be declared null and void soon by Supreme Court, but this did not happen. Why they were saying? They said in Article 15, the basis of this welfare initiative, positive discrimination, affirmative discrimination or reservation policy can be socially and educationally, not economically. Similar steps were taken by Narasimhan government also, P.V. Narasimha government also. And when he was planning that to give 10% reservation for economically weaker section from general category, Indrasani case declared it as a, you can say, unconstitutional step. And this never materialized. So if it did not materialize at that point of time, then how it is working now? Answer is, Modi government first changed the language socially and educationally. They incorporated the word economically. And now all of you know that Supreme Court is interpreter of Constitution. So now government saying, you are interpreter, na? Just interpret what is written. Socially, educationally, economically. Oh, economically is written. It means on this basis, Article 15, Subclause 6 is very much logical. So 10% of the reservation must be set for EWS. Eligibility to get EWS certificate, family income less than 8 lakh per annum, agricultural land less than 5 acre, residential flat less than 1000 square feet, residential plot less than 100. I hope now it is clear to you. Now, talking about Article 16 of the Indian Constitution, it means equality of opportunity in terms of public employment. So there shall be equality of opportunity in terms of public employment, right? And this is applicable only to citizens, and this is applicable to public employment, government job, right? No citizen shall be on the grounds of religion, race, caste, sex, place of birth, along with this residence or any of them, descent and residence. The two more criteria which are added in Article 16, descent and residence. Now for can there be a possibility that certain position may be reserved for a person belonging to a religion? Yes. For example, a position of a pandit, priest in a temple managed by government. So obviously their religion can be a criteria, right? Then Article 16, Subclause 3, Parliament has the authority to provide reservation based on residence also. It means for some government jobs, local population can be given preference, can be given reservation. And what's the logic behind it? Logic is speedy development and equal opportunity to even backward areas, so that people belonging to backward areas can have fair chance to enter into government job. That is the logic. Now Article 16, Subclause 4, most debated article, talking about backward class of citizens which in the opinion of state is not adequately represented in service of the state. It means reservation of appointment and post in favor of any backward class. In earlier, we were talking about 15 Subclause 4, we were talking about policies, right, for backward and SCs and STs, right? And here we are specifically talking about public employment. So in Devdasan versus Union of India case, it was cleared if the reserved seats have not got filled in that year. Consider there are 20 seats and only 10 seats were filled. Now the remaining 10 seats will be carried forward for the next year, means next recruitment, but will become null and void if it crosses 50% ceiling gap. Means I am saying 20, considering that total seats are say 50. But if 10 seats of earlier year and now they are added in the next recruitment and together more than 50% seats are coming in the reserved category, then that particular reservation cannot go beyond 50%, right? Out of 50, you cannot have 30 seats reserved. You can have 25 seats reserved. This was the judgment in Devdasan case. Now Mandal Commission 1979, which started a new politics in India, Mandal Kamandal, Kamandal the Hindu politics, Mandal the backward politics. So now investigate socially and economically backward. Earlier they were investigating the economic aspects as well. Can this be a criteria as well? So there were three important implementations. First of all, reservation to OBCs. Earlier there was reservation to SCs and STs, but they said no, reservation for OBCs is also required. Only in appointment, not in promotion. This was the advice. But later we are going to see reservation in promotion was also added. Total reservation not more than 50%. More than 3,000 socially, educationally backward classes provide 27% reservation. Why? Because more than 3,000 SEBCs are present and they are not allowed to have any reservation in SC and STs category, right? That is why a new category was invented, that is OBC. OBC as a word, other backward classes as a word was not there in Indian Constitution, right? So Indrasani case made this clear that 27% reservation, creamy layer, non-creamy layer are different. Now 16 Subclause 4A, okay, 77th amendment, it was added, and now reservation in promotion for SCs and STs. Then 16 Subclause 4B, added through 81st amendment, ended the 50% reservation ceiling in case of SC and STs. It means if seats are carrying forward, earlier seats were not filled and they are carrying forward and they are passing this 50% limit, then you cannot declare them null and void as per Article 16 subclause 4b. Article 16 subclause 5, reservation in religious institutions. For the post of religious institutions, if the demand is to belong from a certain religion, this is the example I was giving, that for position of priest, position of a Maulvi in a institution position maintained by government, there can be a reservation on the basis of religion as well. You cannot say, oh, it is against Article 16 subclause 1. You should see what is mentioned in Article 16 subclause 5. Okay? Example, Waqf Board, which manages the religious properties of its Muslims. Now, Article 17. Article 17 talks about untouchability, right? Abolition of untouchability. Now, what is the meaning of untouchability? What comes into your mind? Oh, untouchability we know. It is about the practice which is prevalent in this caste system, right? But that is not true. That is just one kind of untouchability. There can be other kind of untouchability. For example, in Sabrimala temple case, that women were considered impure in this age 10 to 55, not fit to enter into the Sabrimala temple, as Lord Ayappa, the deity, is a celibate deity. So this concept of purity, impurity is involved. So if this concept is involved, then it will be considered as a case of untouchability. Okay? So it means untouchability is abolished and practice in any form is forbidden. Any form is forbidden. Okay? So the enforcement of any disability arising out of untouchability shall be an offence punishable. Now, was this offence, what punishment is mentioned in Article 17? No, it is not mentioned. Okay? Now, our last article, Article 18. So, Article 18 talks about abolition of titles. The purpose was, we have seen many titles bestowed on many Indians by Britishers, and it represents the concept of inequality, right? Special treatment. And concept of right equality is against special treatment, as I told you. And that is why Article 18 says that prohibits the conferment of titles. Government is not going to give title. Some of you might say, sir, Padma Shri, Bharat Ratna, you cannot say these are titles. Okay, these are, you can say, for the contribution you have made, you are, given this prestigious, you can say, award, but you cannot use Padam Shri, Shashank Tyagi. Many people use that, but that's not a title. Okay, but titles can be used in military context and academic context. For example, Colonel, okay, Colonel Rohan Sharma, academic engineer, doctor, right? And when it comes to Indian citizens are prohibited to accept any title from any foreign state. But if a foreigner is working on a position in Indian state, then that particular foreigner wants to take, a title, then in this case, then this particular foreigner need to take permission of President of India. For example, Mr. Raghuram Rajan, he was RBI governor. So if British government is giving him a title, then he should take permission of President of India. Okay? Provides that no person, citizen or non-citizen holding any office of profit, trust shall without consent of President, this is what I have explained to you, accept any present emolument or office of any kind in underway by foreign state. I hope Article 14 to Article 18 are clear to you now, right? The provisional aspects as well as the cases which were there. This PDF will be available in Shashank Tyagi for you Telegram channel. If you find any difficulty in any provision, you can shoot me a message. I'll be happy to help you out. See you.